Welcome to another episode of Monday Bagel, the podcast where we explore the intersection of law, technology, and society. My name is Michał Jackowski, and today I'm honored to be joined by Takashi Nakazaki, a leading Japanese expert in privacy, AI, and technology law. He's a partner at Anderson Mori and Tomotsune, serves as an auditor at the Japan Institute for Health Security, and lectures at Keio Law School. Takashi also plays a key role in multiple advisory bodies, including the IBA Technology Committee, the IAPP Asia Advisory Board, and several governmental expert committees in Japan. Takashi, it's great you could join me. Welcome on board. And maybe you can tell us, because Japan is known for its soft law approach to AI, so why has it introduced an AI-specific law?
Thank you for introducing me. This is a very great opportunity to join your podcast program today. At first, Japan is very similar to Singapore because Japanese government is very enthusiastic about promoting AI business in Japan. So they do not want to regulate AI business as much as possible so far.
What exactly is AI Promotion Act?
Yeah, actually, it establishes a national strategy we call master plan of AI promoting actually by creating a central AI policy body. So far, we have no such organization in Japanese government. This time, they decided to establish a central organization focusing on AI promoting and regulating. We call the name of the new organization is Artificial Intelligence Strategy Headquarters. This organization is expected to led by the Prime Minister of Japan and include all cabinet ministers. This headquarters, as I said, will formulate AI master plan. This AI master plan will set the direction for Japan's AI development in the near future, including research and development, and of course, deployment and international collaboration. Especially important point, law acknowledges public concerns around AI. The preamble and Article 1, Paragraph 4 specifically refer to risks such as criminal misuse, privacy violations, and copyright infringement, and other risks. It underscores the need for transparency and safeguards as essential components of AI governance. Also, the new AI Promotion Act says for private sectors actors, the act is non-punitive. We have no punitive provisions. So this is very different from the EU AI Act, I believe. And there are no direct obligations with penalties. But instead, Article 7 of this new AI Promotion Act introduces a duty to cooperate with government. I mean, the business sectors, people should make endeavors to cooperate with Japanese government request to make an investigations on some incidents or other issues. If a private sector company denies such a cooperation with the Japanese government may make the company's name available to the public. By making the company's name available to the public, the company may be subject to the objections from the public.
It's kind of breach of reputation of such yes. The company. Is it correct? So, and what kind of technologies are covered under AI Promotion Act? What is AI in Japan or in this bill?
The AI Promotion Act uses a very relatively broad definition of artificial intelligence, actually. It covers technologies, item one, substitute for human cognitive abilities, such as reasoning or judgment or perception, or item two, involve systems that process input data and generate output using such technologies. So, in comparison with the definition under the EU AI Act, I mean the definition of AI system, our definition of AI artificial intelligence is broader than the definition under the EU AI Act. Actually, our definition focuses more on the functional role. It does not focus on a technical viewpoint rather than EU AI Act definition of AI system, actually.
Okay, and what kinds of government measures must business cooperate with under the AI Act?
Yeah, actually, according to the Act, private sector companies refer to utilizing business operators under our new Act must cooperate with national and local government measures that promote responsible AI use. These measures are detailed in Chapter 2 of the Act, titled Basic Measures. I'd like to see 2 articles that have practical consequences for companies, Article 13 and Article 16. Article 13, this provision is named Ensuring Appropriateness. This provision mandates the development of domestic guidelines aligned with international norms. This means Japanese regulators may increasingly reference international framework as OECD AI principles or G7 Hiroshima AI process. Also, as to Article 16, governmental monitoring and intervention, this provision gives government the power to collect information on domestic and international trends in AI development and to power to investigate improper uses of AI that could infringe upon the rights and interests of citizens, Japanese citizens. This article provides the government the power to provide guidance, advice, or public information to both research and development organizations and businesses. As I said, there are no penalties provisions in the new AI Act in Japan. Public naming of companies that are uncooperative is reportedly under consideration. Yeah, actually speaking, the Act itself does not refer to such making the company's name available to the public, but news articles in the spring said the Japanese government intends to introduce such a system. I mean, making the company's names not cooperative with the government available to the public. So it's as you said, it might be breach of the company's reputations in Japan.
Right.
Yeah.
So
Actually, speaking, this style is very similar to our regulations under the data protection.
Okay.
As you know, in Japan, our data protection legislation, the name is the Act on the Protection of Personal Information, APPI. Under the APPI, we have no severe sanction system like EU GDPR. Instead, Japanese Data Protection Authority, PPC, introduced a system making the company's names available to the public in the data breach situation. And so far, the Japanese Data Protection Authority assume we have sufficient penalty by introducing making a company names available to the public and damaging to the company's reputation. Yeah. This AI, our new AI Act, new AI Promotion Act, is similar in that point to our so far data protection legislation in Japan.
Thank you very much. It leaves me with an idea that Japan is somewhere in the middle between EU highly structured risk-based model and US innovation first sectoral approach. Takashi, thank you very much for making it clear for us, for going through AI promotion plan. Thank you very much for being and joining us.
With pleasure. Thank you.
And for you all, thank you for being with us. Thank you for joining me and Takashi and listening to Japanese Road to AI. If you enjoyed this episode, make sure to subscribe to the podcast and check out my previous conversation with global leaders in AI law and innovation. You can find all the episodes on YouTube. Join us the next Monday and see you. Bye bye.